a super stimulating discussion about how courts are responding to litigation focused on internet shutdowns. Increasingly, we are seeing trends where governments are blocking the internet or social media platforms in an effort to suppress important information from being shared. And often these shutdowns or blocking measures coincide with critical political events in the country, including elections, constitutional reforms, as well as demonstrations and protests. So as more regional and domestic courts hand down decisions focusing on this issue, today's session hopefully will focus on some of the successes and challenges that have arisen out of those litigation, as well as discussing some of the broader impacts these judgments have had in the region. So we've got 4 great panelists who will hopefully share their experiences and as litigators and those working in the civil society sector. So joining us, we have Mojuraya Ogunlana Natanga. So Mojuraya is a legal practitioner and the principal counsel for MON Legal, which is a law firm based in Abuja, Nigeria. Our second speaker is Porritt Hughes, who's the legal director at Media Defense. And we also have Ikechukwu Uzumma, who is the African staff attorney at the Robert F. Kennedy Human Rights, or RFK Center. And then finally, we have Adrien Wayama, a legal officer at SAPISA. So we have just over an hour or so for the session, and hopefully I can soon invite each speaker to give maybe a 10 to 15 minute presentation on their case study before we're going to open it up to a question and answer session. For those that are attending, please do use the chat function at the bottom of the screen to post any questions you may have, and we can hopefully put those to the speakers at the end. I'd also like to encourage you to continue with the discussions online following today's session. Please feel free to use the hashtags FIFAAfrica21 and Internet Freedom Africa to share your thoughts and opinions. And finally, just a quick reminder that as we engage today, we're being guided by the FIFA Africa Code of Conduct, which is available on the event website. So now I'd like to invite our first speaker, Mojuraya, to speak. Mojuraya has been involved in a number of cases before the ECOWAS court dealing with both internet shutdowns and social media blocking. And most recently, Mojuraya, along with Media Defense, has filed an application to the ECOWAS court on behalf of 5 NGOs and 4 journalists after the Nigerian government banned Twitter in June earlier this year. So I'm going to hand over to Mojuraya now to share a little bit more about this case and others that she's working on.
Thank you very much, Saba. Thank you, everyone. Good morning. I hope you've started a day on a bright note. Okay, so where do I go from here? Okay, let me just go straight to the most recent development when it comes to the internet shutdowns and deprivation of access to information. I would highlight Twitter case first. On June 4th this year, the Nigerian government decided that it was suspending Twitter. And when it did that, it also gave out an instruction to the Minister of Justice and the Attorney General, telling him to prosecute anyone who is found on Twitter. And another instruction went out to broadcasting stations, and they were all warned to stay off Twitter or be prosecuted under the National Broadcasting Commission Code and Act. And so it all came so fast. But interestingly, before the suspension on the 1st of June, the president had made reference to the civil war that took place in Nigeria in 1967, and then referring to a particular set of people who really suffered during that civil war, and those are the Nigerians from the eastern parts. So while he did that, the people were not happy. They were on Twitter, they saw the tweet, and they went on to report and flag that tweet. So Twitter took this, of course, it's discretion. It had to, because that particular tweet violated the community rules, and took down the tweet. And so interestingly, if this happened on the 1st of June, and then 3 days later, on the 4th of June, the government decided to suspend Twitter, and then gives a very wonderful excuse, stating that the Twitter's operation threatens the corporate existence of Nigeria. And that becomes quite interesting, really. And when it went on to suspend myself and Media Defense and some of the parties on who felt that they were being that their rights have been violated, NGOs, 4 NGOs, Premium Times, Paradigm Initiative, Media Rights Agenda, TAP Initiative, and then journalists who are frequently on Twitter and who use Twitter as the only medium for them to, sometimes the only medium for them to send out information to the Nigerian populace. So these individuals with these NGOs decided to come together to pursue this case at the ECOWAS court. At the time we decided the ECOWAS court, the Nigerian situation was even kind of dire, because the courts were closed, because there was this judicial action that was taken by members of the pressure groups. And so the courts were shut down. We couldn't access the Nigerian courts anyways. But even if that hadn't happened, we would still have considered the ECOWAS courts because of timeliness, because of the ECOWAS court, the jurisprudence have been built over the years on freedom of expression, and it has been very encouraging, because it remains consistent when adjudicating over freedom of expression, because you could have, there were cases like the against the Gambia, which had led to the removal of Yahya Jammeh at the end of the day, So we thought about the ECOWAS courts, and of course they have these international standards that they have been able to uphold over the years. And we brought our provisional measures application, letting the court know that we don't want anybody to be prosecuted at this time, because one, the violation, the suspension of Twitter violates the rights of Nigerians to freedom of expression. And then we hinge our arguments on the 3-part test, because for you to violate or for you to infringe on the freedom of expression, you must be able to show cumulatively that there is a law that provides for that infringement. You must be able to show that you are pursuing a legitimate interest, and then you must be able to show that the action that you're taking is necessary in a democratic society. And then on that particular note, you must be able to show that the measure you are taking for infringing on the right of freedom of expression is proportionate at that instance. So the Nigerian government cannot, I totally believe, cannot show that there's a legitimate interest. And even before we go to the legitimate interest, is there a law in place? Was there a law at the time Nigerian government decided to suspend Twitter? And so we brought all this before the court, and interestingly, the respondent comes up with its own arguments, stating some laws that have become archaic in Nigeria and have been held in cases not to be that have been held inoperable in Nigeria. The respondent was so quick to refer to sedition laws that has been adjudicated upon in some cases in Nigeria, even all the way to the Supreme Court, where the court had said that sedition is not even it's wrong in a democratic society, and it's no longer in operation in Nigeria. And so they come up with that. which was very baffling that was the argument. And then they also mentioned the penal code. And yes, the sedition they were citing was under the penal code. And interestingly, the penal code is only applicable to a particular region in Nigeria, not to the entirety of Nigerians. So they cited all these. And of course, we went to court. And then we're even in court yesterday. And when we're there in court yesterday, we made our submissions, the applicants. I should also state that SERAP also is in court with respect to this. And as a result of some extra filings from different plaintiffs, the court was mindful of the fact that, okay, let's just keep the issues in one place, and decided to grant a consolidation. And so, while we made our submissions yesterday, and also the defendants also made their submissions, the court had to adjourn for judgment. And we would have loved that the judgment would still be within the year, but the court cited the fact that we have filed a lot of documents, and in analyzing and doing fair analysis of the issues in question, the court would have to adjourn to January for judgment. And that was what happened just yesterday. But I must state that in suspending Twitter, the Nigerian government acted, solely without, it just exercised its discretion, without consultation, without public input, without consulting the right stakeholders, without judicial oversight. So the interference at this instance was just obviously illegal. And I would like to also state at this point that exactly this arbitrary action, unfettered movement from the unfettered application of its discretion, is also happening as I'm speaking right now. It's in Zamfara State, which is a part of a state in Nigeria, Zamfara State, Sokoto, Katsina, and then yesterday, Kaduna State. All these states, what do they have in common? They have shut down telecommunications in their states. And the only thing they've cited so far is national security, and that they are fighting the bandits. And that is what they have hinged that on. And I'm curious, is this legitimate in this instance? Can you just shut people out from access to information? We all know what happened in 2020 when the world was held on its toes. We could not, it was a blackout for the world. And that shows that there is this importance of being on the internet, importance of communication, importance of having access to information. And so, yet again, we find ourselves in a circumstance where the Nigerian government does not appreciate the people's rights to freedom of expression, rights to speech, opinion, and right to access information. And this is really a pity, because it is still an ongoing violence. And that's just what I have to say. Thank you.
Thank you so much, Majoraya. Yeah, it's really interesting to hear, obviously the broader impact the Twitter suspension is having in Nigeria, as well as a hopeful judgment coming out early next year. So following on from that, I'd now like to invite our second speaker, Porrick Hughes, to discuss some of the other cases media defense has been involved in at the ECOWAS court. Porrick, I'll hand over to you now.
Thanks, Saba. Yeah, I just wanted to mention a couple of the cases that we're currently involved in addition to the Nigeria Twitter ban case, which, as Majoraya mentioned, was heard yesterday at the ECOWAS court. In pretty chaotic circumstances, where eventually the court agreed to hear the case and hand down judgment by January, which in the circumstances I think is the best the parties could hope for, given how the hearing proceeded yesterday. So we'll be waiting for that decision with interest, and I'll mention some of the argumentation that was put forward by the government in relation to that case, which was quite curious, given the nature of the shutdown and how they proceeded with it. In terms of strategic litigation in these types of situations, I think it's important always to emphasize that it's essential that organizations continue to bring these cases to domestic courts where the opportunity arises, or international courts, if that is possible. And of course, it depends on the circumstances, the jurisdiction, and what avenues are available to lawyers to explore. For example, in Nigeria, in Guinea, in Togo, there has been that opportunity to go to the ECOWAS court, which has been quite receptive to arguments concerning freedom of expression and press freedom around internet shutdowns and the impact on individuals for their human rights. But I think it's also important to remember that it's possible to extend or expand on the nature of the arguments that are currently being made before those international courts. And I'll just mention a couple of things in a moment. But as a broad point, I think it's very important that we continue as lawyers to litigate these types of cases before international courts, because there is, as you can probably see, when litigating these cases, we do tend to rely on a lot of documentation coming out of NGOs who carry out a lot of advocacy around that area. So there's lots of advocacy being done, but oftentimes there's a lack of legal challenge being brought. So I think the courts are an excellent outlet to ventilate arguments around why internet shutdowns are a violation of human rights in the way in which they're being implemented. And they work together with advocacy by other organizations, hand in hand, one part of a larger tool set in order to put pressure on governments to refrain from engaging in internet shutdowns. The other advantage of continuing to take cases to international courts and tribunals is that those courts and tribunals are then able to set standards. In different cases, you're going to end up with different factual circumstances, primarily because the nature of internet shutdowns can change from case to case. For example, yesterday in the Twitter Nigeria ban case, we had the government stating quite forcibly that it hadn't actually shut the internet down. All it had done was shut Twitter down, which I don't think is a very strong argument when it comes to the right to freedom of expression, and doesn't necessarily answer the arguments that were put forward by the applicants and the amici in the case. But that is just an example of how that case differs from, for example, the Togo case, where the ECOWAS court was dealing with a full-on, complete and blanket ban on the internet, or with the Guinea case, where the same kind of issue arose on the first occasion of the internet shutdown, and then on the second occasion, the internet shutdown involved a kind of throttling or suppression of the network. And then if we reach back further, we can see what happened with the Anglophone region in Cameroon, where there was a complete internet shutdown, a blanket one for 3 months. So it went on for quite some time. So you do see a kind of emerging trend when it comes to internet shutdowns of governments taking different approaches to how they're going to suppress information being shared and being disseminated, from a full internet shutdown through to throttling of networks, so that it makes it quite difficult for individuals to share information. An interesting further development has taken place recently in Myanmar, where organizations have referred to what they call whitelisting, where you end up with corporations and government agencies and so on being able to access the internet through fiber optic cables. But for the mobile network, for the general population, it's much more difficult to use the internet. So there's almost like a two-tier system. It's almost like this kind of idea of net neutrality, where you've got two different ways of accessing information on the internet. One is quite straightforward. The other one is very difficult, almost impossible. So this idea of whitelisting organizations to allow them access while blocking it for the general population is a new and emerging trend. And I think it's fair to say we saw a variation of that in the Guinea case, where we had embassies being able to access the internet while the general population was unable to send messages on WhatsApp, to tweet about things, and so on. So there are variations in the way in which internet shutdowns are being implemented. So it's important that I think litigators understand that courts will have to use different tools to confront these different kind of factual scenarios. But the one constant in these types of cases is, as Mojo Rao mentioned, the three-part test. I mean, that is the kind of the bedrock on which all of these cases rest. And as Mojo Rao mentioned, it is a cumulative test. So one slip by the government in relation to any aspect of that three-part test and their actions can be considered to be not only an interference, but a violation of freedom of the right to freedom of expression. So there is a kind of an emerging pattern in the way in which countries implement these shutdowns, but that doesn't take away from the kind of core and essential fundamental legal arguments with which to confront those shutdowns. That is the three-part test. And that is the case law from the various courts that are dealing not just with internet shutdowns or social media blocking cases, but generally in relation to the right to freedom of expression, where you have international standards being set from the European Court of Human Rights, from the Inter-American system, and now from the ECOWAS court for example, in the Togo case. Although I would say the Togo case lacks, it's quite clear, but I think it lacks weight in terms of how the court dealt with the arguments that were put forward by the applicants. Mojo Rao was counsel along with Media Defence, and myself and Saba in that case. And the judgment is a short judgment, which doesn't really grapple with the kind of the substance of the legal arguments that we were putting forward. Although it in one way, it's quite a welcome outcome because the findings were very, very broad. And they were deployed yesterday in the Nigerian Twitter ban case during the hearing. Reference was made to the Togo case, and we heavily rely on it in the Guinea case, which we recently filed at the ECOWAS court. So in broad terms, you're seeing a large number of cases being filed at various regional and international courts. The hope is that the courts will develop standards. I think it's important, for example, in relation to yesterday's case, the government put a heavy emphasis on national security as the legitimate aim it was seeking to use to justify the interference with the right to freedom of expression. And this tracks quite closely with how governments reacted post 9/11 when they were introducing all of these draconian laws around arbitrary detention and so on, where they would rely on the national security argument. So again, you can see how if you go outside the arena of freedom of expression and you look into those types of cases that went before the European Court and other courts around the world, you can see how you can use arguments in those cases to push back against the national security argument, which is often, if courts are not careful, often a winning argument, where by simply saying that it interferes with national security in some way without specifying how, you will find judges are often very reluctant to challenge that because of the possible consequences if there is actually a genuine challenge to national security. But as I say, in the context of the 9/11 post 9/11 legislative framework in various countries, that has also been the subject of challenge from applicants successfully, where standards have been developed. So I think it's important to look outside the freedom of expression arena and to be cognizant of the possibility of relying on those kinds of precedents. And then the final thing I'll say in relation to this type of litigation is it's oftentimes not just a question of challenging the government or the country, the state. You can also challenge the Attorney General, ministries, identify individuals. But I think you can also go outside the framework of government and you can look to the telcos. And that's also something that should be taken into consideration. I understand in Nigeria, there's a case emerging around a challenge to a class action, essentially taken by people who have signed up to a particular mobile phone company who are challenging that telco's decision to shut its network down or not to make available Twitter on its network. These are tricky cases. This is the kind of outside the public law arena, you're entering into contractual obligations between parties and the obligations of telcos to comply with essentially orders coming from the government, even though those orders may not have a legal basis. It is a difficult area, but it will be interesting to see how that develops. But in broader terms, I think it's important that people who seek to challenge internet shutdowns, social media blocking, and so on, look outside government agencies and seek to challenge those actions against telecommunications companies. In particular, where those telcos are subsidiaries of larger telcos, which are operating in other jurisdictions, whether pressure can be put on them. And I know in the Guinea case, there was a question of whether Orange was one of the telecommunications companies that complied with the government's order to throttle the network and to shut the internet down. There was some activity around whether or not Orange's the French corporation, of which the company in Guinea was a subsidiary, would take any actions following the decision of the subsidiary to throttle the internet or to shut it down. The final thing I'll mention is just very quickly 3 things that arise in relation to litigation for us. The importance of having claimants who stay the course, which is quite difficult. We saw in our Cameroon litigation, we were working with a Cameroon lawyer, Emmanuel Nkia. Of 8 claimants in that case, in those cases, there was a number of them. 7 fell away. We ended up with 1 case, and that case is now before the African Commission, having been unable to secure an effective remedy in the domestic courts. The second issue is securing appropriate evidence, which is difficult. I mean, you can, of course, suggest that the burden of proof shifts from you to the government where actions are taken that shut the internet down. That's one way of dealing with that, but it's important to get evidence. And I think public pronouncements by government ministers and so on, if they're not careful, can be very helpful. And then thirdly, the court that you go to. So far, we've been involved in cases before various international courts and the domestic courts in some jurisdictions. In one jurisdiction, the domestic courts were not interested in the case, and we would suggest actively sabotaged the case, how it was proceeding through the court. So we eventually ended up going to an international court. So choosing the courts correctly is very important. So on that note, Saba, I will leave it there. Thanks.
Thanks so much, Porek, for giving that kind of broad overview of some of the different cases that Media Defence is working on. I know there's some questions that have been posted in the Q&A. Please keep posting and we'll get to them at the end after all the speakers have kind of spoken. So I think one of the other important factors within strategic litigation is the filing of amicus briefs. Often these filings can signal like broader issues that are involved and its wider impact than just the named parties that are involved in the litigation. So that being said, I wanted to invite our third speaker, Ikechukwu, to discuss the practical realities of filing an amicus brief. He recently represented RFA in their application to be amici in the Twitter ban case at the Equus Court. So I'll hand over to him now so he can provide a little bit more details about that.
Thank you, Saba, and thanks to Media Defence for the opportunity to speak on this panel and for the great work you all do. I am Ikechukwu Uzoma, as Saba mentioned, and I'm the staff attorney for Africa at RFK Human Rights. I am Nigerian. And, you know, what I would propose to do, in the next 10 minutes would be to first reflect on the process that we went through for determining whether or not to file an amicus brief in this case, the Twitter ban case. And then secondly, to talk through the procedure for participating as an amicus courier before the ECOWAS court. Reflect a bit on the content of the brief, and then round off by just talking a bit about best practices and lessons learned. And, maybe it's useful to start even from the bottom just to reference a useful tool that Media Defence supported in putting together and was shared earlier in the week, which is the UNESCO guide for participating or filing amicus briefs in cases pertaining to freedom of expression. It's an 18-page document that really does highlight the most important considerations for filing amicus briefs, and I would really encourage all the participants to take a look at that. It will definitely speak more elaborately to the process than we can do in 10 minutes. That said, it's useful to start by just sharing that an amicus curiae is a friend of the court, literally, and in that connection, it's typically an NGO or groups of NGOs or an expert or group of experts that either apply to the court to be admitted as amicus curiae to support the court in determining the case before it, or sometimes invited by the court based on their expertise to support the court in elaborating on a certain aspect of the subject matter before the court, or even the entirety of the case. And it's useful also to mention that most people will be familiar with the third party in a civil case. But the difference here is that the amicus curiae is not necessarily a party to the case. It's really, the amicus curiae just comes in to support the court in reaching the determination. Ideally, the amicus curiae should be objective and not partisan, or not really supporting any party in terms of the form of the contribution or participation in the case. But for the most part, in this context, amicus curiae briefs usually highlight, international law, jurisprudence from that are beyond the reach of the court, to help the court to reach a determination that doesn't only do justice in the case, but in most cases equally contributes or supports the growth of jurisprudence around the particular subject matter. So that said, it's useful to state here that in terms of our consideration or determination of how to intervene or how to support the case, it's useful to mention that we had been in touch with the socioeconomic rights and socioeconomic rights and accountability project, SERAP, who's one of the applicants in the case, talking just about collaboration broadly on some of their cases pertaining to freedom of expression and civic space broadly. And this happened months before the Twitter ban came into force on June 4, and the case was filed. And I say that to highlight the fact that the most useful preparatory process towards filing an amicus brief is usually, getting your hands on the facts of the case in its entirety and determining the scope of the case and therefore the scope of your intervention as amicus curiae. And in this case in particular, just as Mujirayo had mentioned, the Twitter ban came into force at the time when the courts in Nigeria were shut, and so the ECOWAS court was actually the only alternative at that point that didn't require exhaustion of local remedies as some mechanisms, human rights mechanisms, require. And the application by SERAP, which was the first one that was filed, before the others came through, equally had an application, an interlocutory application, asking the court to grant expedited hearing in the case, as well as seeking an injunction for the court to preclude the Nigerian government from proceeding with prosecuting Nigerians who used Twitter either by, through the instrumentality of the virtual personal network VPN, or, people who were circumventing the Twitter ban. And the court granted these two orders. When the court granted these orders on June 22nd, the timeline for filing the amicus brief changed radically, because ideally, based on the rules of the court, of the ECOWAS court, which I should state at this point, doesn't explicitly, as other courts, like, for example, the East African Court of Justice doesn't explicitly provide for, an amicus curiae intervention. But it provides for interventions broadly. But the court had, in several cases before this, ruled that the Article 89, I think, or Article 89 of the rules on interventions covers amicus briefs, and so that was the basis upon which we filed. And I say this just to highlight the fact that one of the first steps to take, after this determining to file an amicus brief, is to gain familiarity with the rules of the courts concerning the amicus brief. Usually, it's best practice in most instances to either coordinate with lawyers who are used to the court or who have filed amicus briefs at the court before determining to file, just to make sure that all the procedural steps are taken. And in this case, because of the expedited hearing, ideally the courts usually would allow amicus briefs to be filed within 6 months of the filing of a case. But with the expedited hearing and on the 22nd, and a date for definite hearing on July 6th, we needed to file as soon as possible to ensure that, primarily, to ensure that our application doesn't delay the process of hearing the case, because that's usually that's a concern, and it's a consideration. Remember, the goal usually is to support the growth of jurisprudence, to support the advancement of human rights, and not necessarily the trail, if that exists, of filing a brief. So you have to go through a process of careful consideration to make sure that an amicus brief doesn't hurt the case, either procedurally or substantively. And again, making reference, to that guide I spoke about, it reflects on this process, on this determination process, in detail. And I'll really encourage everyone, to take a look at the guide. And so in 1 week, we had to file the amicus brief. However, because of our already existing relationship with SERAP, and because we knew a lot about the case, it was easy to put the brief together in a way that equally supported the arguments that were being made. Another lesson that we've learned, and it's actually a best practice in supporting cases as amici, is to ensure that the brief that is filed doesn't rehash the arguments that are already before the court, because the brief it should be supportive and not enlarging the responsibility or of the court, or repeating arguments that are already in the court's notice or knowledge. So being aware of what's being filed by the applicants in the case, and if possible, even by the respondent, is useful in order to ensure that the contribution is beneficial to the court. Again, so in this case, our relationship with SERAP was critical in determining that it was important, or it will be supportive, not just in this case, but to the broad advocacy strategy around the case. Because usually strategic litigation is one component of a broad strategy built around the case. And it's important to keep that in mind. And so the amicus brief or participating in the case as amicus curiae should support that overall and overarching goal, as opposed to anything else. And so we decided to file, and had reached out to other organizations that we usually do work with. We equally had a chat with Media Defense, with Access Now, and with other colleagues. And the intention initially was to file a joint amicus brief with other organizations, which is equally something that I usually recommend, because it's usually important to in supporting cases to ensure that the contribution that is made is robust enough to provide the court with all the information, all the standards, all the jurisprudence that they may need in reaching that determination. And it's easier done when it's done collaboratively. Again, sometimes, in filing briefs, you will need to, the organization would need to retain local counsel in the jurisdiction of the court. In this case, it was the ECOWAS court, so it was a bit different. And in doing that, it's usually easier when you collaborate with an organization that maybe has a lawyer based in that jurisdiction. And so because of the short timeline, we had to file before the hearing of the court. And we made our application based on the rules of the court. It had to be within 15 pages and not more, and had to define or introduce the amicus, talk about the experience of the amicus and why the amicus, the organization believes they can make the contribution in the case, and then include the arguments. And there also had to be an application, a motion or notice asking the court to grant leave to us as the RFK Human Rights, as the intended amicus curiae, to join as amicus curiae. So the procedure needs to be followed. You need to learn what the procedure is. In the case that you don't know what the procedure is, you need to find out well ahead of time. And then in talking about the content of the brief, just like Mojiraya also mentioned, we did focus a bit on the three-part test based on Article 19 of the ICCPR and Article 9 of the African Charter. But we went forward to pull on jurisprudence from the European Court of Human Rights, the Inter-American Commission and the American Court, and even the jurisprudence from domestic courts within Africa, and the jurisprudence of the East African Court of Justice, all to support, the fact that the right to freedom of expression does extend online. And then we also had a bit of a conversation around anonymity and the privacy concerns, just the right to use, anonymity devices or softwares such as, VPN, in cases of communication online, given the attacks on online communication and the usual reprisal that follows critical comments to the government, and so that was like the niche area. because we already saw the briefs and we knew that there was a conversation already on international law, on the standards. So we just contributed that aspect of anonymity and encryption as a component of the right to freedom of expression online. And, in that, there's also a lesson learned. Again, we can't say it enough that, the brief has to be complementary and has to supplement what already exists and not rehash, what does exist. And in rounding off, I'll just to share a few more lessons learned and best practices, of filing amicus briefs. One is the fact that, just like we said, you have the intending amicus brief the amicus courier has to be aware of the procedures of the court, has to follow those procedures. It's usually important that, if you are not familiar with the jurisdiction, you have a lawyer, even if that lawyer would not argue the case, but sometimes to do the necessary follow-ups. Because with this case, the timeline was short. We need to make sure that the filings had been received by the court. We usually had to, call a registrar at the court to share that, okay, we filed this document. Can you please confirm that you received it? And sometimes we got feedback saying, yes, we received it, but this is missing. We need this, we need that. One example will be the fact that this was my first time litigating before, or, representing an amicus courier before the ECOWAS court. And the ECOWAS court required my license as a lawyer in Nigeria, my call to bar certificate, and a few other things. And I only found out after we reached out to the court. So it's usually great to be a bit proactive in terms of keeping, following up with filings before the court. Again, you need to be aware of the hearing dates, and be in court even if you are not invited, so to speak, because again, you're an amicus in the case, not a party to the case. And in our case, we were not informed about the hearing. But again, we kept in touch with all the parties. We knew about the hearing. We got the link and proactively introduced ourselves to the court as amicus courier and mentioned that we had an application before the court. The other is to ensure that the brief is objective as much as possible. Refrain from using language such as, we urge the court to grant the relief sought by the applicant, and instead use language that is objective. So, language such as the position of international law supports the argument of the applicant, as opposed to, taking sides, as it were. And then always go through that process of determining whether or not the amicus brief supports the case, and ensure that care is taken to avoid elongating the process of the case, or having the amicus application lead to unending adjournments. In this case, we had the conversation, among the organizations thinking of filing the amicus brief, and we knew this was a risk that the courts, that the defendants in this case could decide to use the filing of an amicus brief to elongate the case and ask for adjournments. And we had an alternative plan. And that alternative plan was that if there was a call for adjournment, we would withdraw our amicus brief, because the amicus brief is not as important as the main application before the court. And, everyone should be ready to take such steps to ensure that the intervention is supportive and doesn't detract from the success of the case. There's a lot more to be said, but I know I'm out of time, and I would like to stop here. I'm happy to answer questions afterwards. Thank you, Saba.
Thanks so much. That's really useful to describe some of the processes and the advantages these briefs can have within strategic litigation. I'm conscious of timing, and we still have another speaker to present. So we've heard from various litigators about the processes and the impact of strategic litigation. But I now actually want to move on to our final speaker, Dream, to provide some perspective how internet shutdowns affect civil society organizations and how they can actually get involved in litigation if they aren't necessarily lawyers or working with lawyers to push these cases through the court system. So I'll hand over to Adrien now, and then we'll have a short Q&A after.
Thank you very much, Saba. I'm glad to once again take part in this wonderful session on strategic digital rights litigation and sharing from a perspective of how civil society has been affected in Uganda, and of course how this effect even stretches on even to touch other countries across the region or across Africa. So as a way of beginning, I wish to note that this shutdown or internet shutdowns have not come as a surprise, but it's now a virus that is being mirrored or replicated across the continent, from eastern to western, from northern through the central to the southern parts of Africa. And it seems to be by governments that want to stick longer in power, or that want to curb down on criticism, or that want to demand for transparency and accountability, and so on and so forth. So in this, we must also note that civil society is a government watchdog that usually looks into the activities and decisions of government, and then finds a way of holding governments accountable and answerable for the decisions that they've taken, and yet affecting individuals, most times from a negative perspective, though of course they also observe what the positive impact is. The other aspect that we must note is that from Uganda, it's not the first time internet shutdowns are actually happening. It has been on for quite some time. It started with threats on websites of key media houses that were highly critical and exposing information that would have otherwise been preferred to stay hidden from the public. And then, of course, we stretched on to 2016, where social media was actually blocked during the electoral season. While people were casting votes, social media was down. And at the same time, during the inauguration of the president, still it was shut down to deny people expression and sharing of information online. And then later on, of course, it stretched into the worst of 2021 during the general elections, when the internet was completely shut down. This time it did not matter whether it was social media or anything else, but it was total shutdown. And this lasted for close to a week. And even then, even with the restoration of the internet, some social media platforms like Facebook could not be accessed. They were completely blocked. Up to date, Facebook is inaccessible because of the standoff between government and Facebook. So this shutdown has had innumerable effects on civil society. From a perspective of number one, that the shutdown in the first place paralyzed work of CSOs, of civil society organizations. Since most of this work is actually done online, you can attest wherever you are that once you have internet disruptions, actually you cannot work. So for all those days, it was quite visible that civil society would not carry on its work. There were also denials of access to critical information, as well as sharing and disseminating of that information to the targeted recipients. And of course, this, as my colleagues have alluded, was quite contravening of the established regional and international human rights standards, especially from the perspective we're speaking about in terms of the tests that probably a restriction must meet. And we must also know that these restrictions should not be beyond what is actually acceptable from an international or from a human rights perspective. And then secondly, the internet shutdown has, of course, caused certain fears among a civil society in as far as their work and operations are concerned. One, because they fear that in case they become again highly critical, or if anything is important is coming up, then government is likely to take similar measures against the key enabling platforms such as the internet or social media that is used for carrying out those activities. And that would bring us again to the aspect that this also further reveals that despite enormous and wide work of civil society organizations, especially in light of meeting reporting obligations where government is actually exposed at human rights monitoring mechanisms such as the Universal Periodic Review, but government has not actually been complying. So it sounds some warning bells to people that despite all this work and the efforts and the repetitive exposure of the wrongs, they continue to happen. So the future of digital rights and freedoms, especially for citizens and non-government organizations, is quite uncertain, as they cannot be sure. Because from that level, other states are saying do this, but governments are not doing it. So it poses quite a number of questions that really require serious action and attention. And of course, you know, within the time of internet shutdowns, usually organizations have also reporting organizations, say for reporting obligations to donors and the donor community, and they have to meet those obligations at specified times. Sometimes the sites for reporting are closed for as long as the deadlines are met. But within that time, quite a number of organizations had to suffer the consequence and failed to meet the reporting obligations to donors. But we hope that this must have been changed because no one wanted the internet to be shut down, but that is what happened. And then the other impact that we can really meditate on more seriously is that transparency and accountability, especially in the democratic processes, was actually affected, jeopardized, and underlooked. Because civil society, as I noted earlier, plays a watchdog role. And this was a critical time of democratic shaping, of exercise of universal adult suffrage, where people are going into voting to make choice of leaders. And they would actually want to know how the turnout is and how the tallying is being done until the declaration of a final leader. But here, in the darkness of internet, you could not expect any of those things to happen because you cannot send information much easily. You cannot reach a large number of people. You cannot even be sure of how transmission of results is being done, since countries are quite big, and internet or the digital platforms are being proved to be the most effective way of transferring results. So here it brought transparency and accountability at doubt. And similarly, also it put a question to how, if civil society can actually play a very important and critical role in as far as transparency and accountability is concerned. Because even when they wanted to push for it, they were blocked. Even when they wanted to do it, the medium through which they would do it was not functioning. So that exposed and it creates room for opportunities that must be explored, as I briefly highlight as I close my short presentation. The first thing is that there are certain opportunities that civil society, together with other key players, can undertake to ensure that amidst the happening of the things, at least there should be some measures to stop whatever is going on, or to shield the public and citizens from reoccurrence of such things. The first one is the exposure of true and intended acts of government regards to digital rights and freedoms. This can be done through a number of ways. It can be done through advocacy, it can be done through research, it can be reporting and exposing the different acts that probably government is involved in, and also pushing government to desist from doing similar acts. The other aspect is to make use of the human rights reporting mechanisms, such as the one I mentioned, the Universal Periodic Review. And Uganda will be reviewed in January 2021. We have already submitted different reports that touch digital rights and freedoms. And I must note that even from the previous reports, just like any other countries that are mentioned across the continent, they have been submitting reports with similar issues to the Universal Periodic Review, but the governments have increasingly jumped the obligations or the mandatory requirements that are raised in relation to that, and done similar acts and gone back to aggressive actions that should actually not be implemented. So, but nevertheless, now that there's been a total internet shutdown in Uganda, Tanzania, and all other countries, the opportune moment is to make use of the 2021 review process that is coming up, so other countries can actually ask or review the human rights record of Uganda and other countries and ask them to oblige and follow the existing international and regional human rights mechanisms. One of the other important ones, what we call the collaborative efforts of civil society organizations against government and its agencies for digital rights violations. One of the most important collaborative efforts is the one we're talking about here, which is litigation of digital rights and freedoms. And this litigation, of course, can be aimed at asking courts to intervene into these processes as a third arm of government, in addition to Parliament and the executive, to issue judgments and decisions that bind the government and call upon the government to oblige, respect, protect, and promote digital rights and freedoms. But the collaborative aspect comes in such a way, as we've spoken, as you can hear from our colleagues in Nigeria. There have been collaborative efforts in Kenya, Uganda, Tanzania, in Guinea, Zambia, and some other countries. The importance of collaboration is that collaborative efforts bring together different forces, forces including the small forces, the weak forces, and the strong forces. They come together and create one big force, which then they play the courts. Indeed, when they present that, courts are more willing to listen to them because they represent a wide spectrum, as opposed to situations when courts are approached by one small organization or one particular individual. So collaboration is good for that fact that it makes the action thought after stronger and more convincing, that the desired goal may actually be achieved, that the desired objective will be attained, to ensure that digital rights are protected and promoted, and as well respected. As I wind up, I also want to comment on the fact that in this collaborative effort, that civil society organizations and other key players, such as the media, telecommunication companies, internet service providers, need to also realize that in approaching this, they need to plan their cases well, bring different professionals together from all walks of life. This thing is not only about lawyers. For example, you can bring computer scientists, managers of institutions, because you'll have different aspects being integrated in the litigation with a planning and having a professional touch. And then it can be pushed on to ensure that even in the presentation of the case, it highlights all the relevant issues that require court attention for it to adjudge on them to ensure that actually people enjoy the digital rights and freedoms as they should. So with that, I will also want to stop here and we'll be able to invite any questions or queries or comments that our wonderful participants may want to raise or may seek clarity on this aspect of collaborative digital rights litigation. But maybe just before I walk out, I want to differ from what my colleague, I think Okechukwu, spoke about when he said that the difference between the main litigation and Amicus is that the Amicus is not that important. Yes, the Amicus may appear not to be that important, but I want to re-emphasize that it's very critical because these are friends of court who bring further evidence to courts of law, and that court can choose to ignore or is chosen or information from that amicus. Then it becomes very, very, very important and critical. So with that, I want to hand over listening to me and look forward to the different questions and comments that may be raised. Thank you very much. Over to you, Asaba.
Thanks so much, Edrine, for providing that perspective from the civil society organization. We have a few moments left, I guess, at the end, just to answer some questions. I know that a question's been posted in the Q&A, which I'll read out, and it says, in your view, Moderato, is there a remedy at national level at all, apart from ECOWAS, with regards to freedom of expression? The case is a bandwidth and all, there are international standards that lay out what needs to be done in the interest of national security.
Thank you, Saba. I've actually seen the question, and there are actually mechanisms in the country. Okay, for instance, when Nigeria acceded and then adopted the African Charter, not only did it adopt it, it's formulated, or should I say, it produced the freedom, the fundamental rights enforcement procedure rules. And it is basically aligned, or it's basically in line with the African Charter. And so that particular document gives you, apart from the fact that under the Constitution, you can go under Section 46, apart from going with that to ask that to ask the court to intervene in the circumstance that your freedom of expression has been violated. So you can use the fundamental rights enforcement procedure rules, and of course it is not subject to the usual timelines that cases would naturally the usual flow of cases. It has the rules provide for expediting of hearing, but interestingly that doesn't happen. I can say for myself, in 2019 Nigeria presented a social media bill, and when it presented the social media bill, some of us came out and then we did a lot of advocacy. And then a client walked up to me and said, please go ahead and file against the Nigerian government over the social media bill. So, and that is a media rights agenda. So we have been at the Federal High Court since 2020, January, thereabouts. And what are we saying? That the fundamental rights of Nigerians, the fundamental rights of my client, for instance, it's likely to be violated should that social media bill be passed. So the Constitution under Section 46 has already given me the leeway to say, if there is likelihood of violation, I should come before the court. So I look at it and say, oh, there is likelihood of violation of my freedom of expression, and then I'm going to court on a bill that has not become a law. And that's the matter was adjourned till, I think, October this year. So imagine how long it's taken for me to get justice or to get the court to even intervene in my matter. So that is why, you know, the national courts can be a bit of a challenge. But of course, we know that there are international standards, we know, and it's still clear that whatever you do, even when you want to use the defense of national security, terrorism, the court says at all times, or even the United Nations has said that you must ensure that you follow international rights standards. And then it tells you also that the rule of law is important. And then, you know, then of course, delay would be the main challenge at the domestic level. It would be your main challenge. Now, just the second challenge that may be not too obvious, though, is that we don't have an active judiciary as we used to have prior to 2015. Prior to 2015, some judges were still willing to take they were willing to show their activism on the bench and tell you that, okay, though this is not the norm in Nigeria, I am applying the international standards in my judgment. But we don't have those judges today, unfortunately, because the power, the strength of the judiciary has been whittled down by this administration. And a lot of judges, I can say that, are not as bold as they would have wanted to be. So they always restrict themselves to the laws that are available in Nigeria and then restrict themselves to what is just there. So me citing the ICCPR, for instance, may not be able to sway the judge, even though the judge knows that Nigeria has assented to that particular convention. It may come up with this, oh, well, it's just a persuasive argument. After all, it has not been domesticated like the African Charter. So those are the challenges that we go through when we actually go before the national court, and that's why we always prefer regional courts or international courts. Thank you.
Thanks so much, Modero. Perhaps we can just have one more question before kind of wrapping up the session, and this is open to any of the panelists that want to jump in. But broadly, what are some of the main trends we're seeing with governments implementing internet shutdowns across regions?
I'm happy to just mention a couple that we've seen in the course of the cases we've been involved in. I think in terms of trends that are emerging, we're seeing, for example, longer shutdowns. I think you might recall on the Cameroon case, we were dealing with the shutdown. The first shutdown was a 3-month-long shutdown. Since then, we've seen very long shutdowns taking place in Ethiopia, in Myanmar, and in Kashmir. We've seen those shutdowns ongoing over months, and in the case of Kashmir, over years. So essentially, you're getting governments to use this as a kind of an ongoing weapon against the dissemination of information, the sharing of information. In terms of challenging that, I know there have been a number of interesting developments in terms of litigation in India around related points, and it will be interesting to see whether or what challenges have been brought in the context of some of the longer internet shutdowns there. I think the other pattern you see is that internet shutdowns you can almost predict when they're going to take place, because they often take place just before elections or just before protests. So that raises the question in terms of strategy, whether it's possible to bring an action for example, an injunction to prevent government authorities or people in positions of power relating to the provision of internet services, not to shut them down, whether they can be brought against private entities in the form of telecommunications companies or against government departments, simply stating that there is a more than reasonable prospect that the internet will be shut down in anticipation of a protest or in anticipation of elections, and whether it's possible in a particular jurisdiction to secure a court order stating that the shutdown should not happen. I think that will be a curious litigation avenue to explore. And then I think the third thing, and this relates to a case that Media Defence filed at the European Court recently in relation to a conflict zone, we're seeing internet shutdowns taking place in the context of conflicts in specific regions and specific areas. And I think in the context of the Azerbaijan-Armenia conflict in Nagorno-Karabakh in October of last year, we had a shutdown of services whereby individuals couldn't communicate with each other during a sustained bombing campaign by both sides. So that's another pattern you're seeing where it's being weaponized in the course of armed conflict, and whether that is a fruitful source of litigation in terms of pushing back against that. I think it's mentioned in our brief, and we're dealing with other aspects of that conflict, but we don't necessarily focus on it beyond saying that it's indicative of an effort by the defendant or the respondent state in that case to suppress the sharing of information. So those are the kind of general patterns that have been emerging over the last 2 to 3 years. But of course, counter to that, there is the very useful pattern of all of these activities being challenged before domestic and international courts, and of course being done so by coalitions of organizations that are developing their argumentation and trying to secure stronger jurisprudence.
Thanks, Parag. I think, did you want to jump in, Ikechukwu?
Yeah, just to add to Craig's comments, we've also seen, and this, I usually wonder why internet shutdowns during certain countrywide examinations. This has happened a number of times in Ethiopia. And then the other would be shutdowns by, components or local governments in states, maybe not the federal government that is usually the party, especially in the context of federal states. The federal government is usually the party to international treaties and the party, before international mechanisms. But we are seeing, just like Mujiraya mentioned, the governor of Kaduna State, saying that telcos would have to shut down communication. And in that case, in the context of the ECOWAS Court, for example, the governor of Kaduna State will not be a party, if there's a suit before the ECOWAS Court, because, the governor, the state itself, like that's a component part of the country, is not a party, to the community, the treaty of the community. And then, just to go back to Adrian's comment, I didn't intend to talk down on Amicus Korea participation. My comment was basically as to just keeping the goal primary and ensuring that the applicants and the plaintiffs are allowed to go on with the case. If we notice, an intention to delay the case because of an Amicus Korea brief, because there are definitely other ways to support cases in terms of advocacy and the like. So, of course, Amicus intervention is critical, and we do a lot of that, but in the case where we find sinister moves by the defendants to prolong the case, then maybe there's a determination to be made as to whether or not that is the right intervention to be made. Thank you.
Thank you so much. We seem to have a flurry of questions that have come in, and we only unfortunately have about 10 more minutes left of the session, but perhaps I can address one to Adrien that's just come in, which says that apart from collective measures, how can we defend our freedoms from such violation of our rights to information, like what happened in Uganda during the 2021 total shutdown of social media?
All right, thank you very much. I appreciate the question. Of course, as I noted much earlier, the best way of challenging illegal actions of government is usually using the courts. Most times that's at the national courts. If the courts fail, the national courts fail, then we can approach the regional courts or the international courts later. So in this respect, we cannot say we're going to use guns to fight government and force them to put back the internet. But it is mainly litigation. The only way we can do is to challenge using the law. But we can also write reports. I have talked about the international human rights monitoring mechanism, such as the Universal Periodic Review. We can use that, and then other states will put the state of Uganda through its representatives on toes, asking them, why do you do this? This is not wrong. We recommend that you stop doing this. And of course, those recommendations are not binding, but most times they have a contributory role that they play on ensuring that government complies with its obligations or international obligations. That's one. Two is that there could be also an option of individual litigation, but as I said much earlier, individual litigation does not collect or is not good enough in bringing together force or strength or power that we can call for courts to actually intervene. But public interest litigation cases, especially involving a number of interested parties and organizations, lawyers, and professionals, are likely to pick the attention of the court and even of government. A mere presentation of a case in court, even if it is not attended to and judgment issued, but the moment it appears and it has lawyers, it has computer scientists, it has civil society organizations, it has telecommunication companies and internet service providers. Of course, government would even respond or to the issues they are raising even before the court actually listens and passes judgment. So there are other ways as those, but the best option, as I've said, is for it to be more effective and to deliver the intended results is that joint forces usually much better. So the others are peaceful ways like the Universal Periodic Review, and then maybe individual litigation, maybe writing reports and sharing them with governments and specifying the different recommendations that they need to take on. Yeah, thank you.
Thanks so much, Adrien. So, sorry, just going through and seeing if we've got time to answer one more question. Someone's posted about the SADC tribunal being abolished in 2011, which leaves no regional court to protect against internet shutdowns in Southern Africa. So there's a question to ask whether anything can be done to highlight and support the campaign to revive the SADC tribunal, or alternatively, what other kind of methods or avenues there are for those in that part of the region to challenge internet shutdowns. I don't know if any of our panelists have a view on that or want to make a short contribution.
Yeah, I'm happy to speak to that a bit. Yeah, the removal of the human rights jurisdiction, so to speak, from the SADC tribunal is regrettable. But however, there are efforts to challenge these internet shutdowns within countries, and I think for example, I know the Zimbabwe Lawyers for Human Rights challenged the internet shutdown in Zimbabwe, and I know equally of the Article 1 case in Zambia, and there are other cases in other parts, and definitely the cases that were filed in Eswatini during the internet shutdowns, even though it was withdrawn after the internet the shutdown was lifted. So what is useful in this circumstance is to continue the advocacy, which at this point is more political than anything else, for some form of the reinstatement of that mandate, and the creation of mechanism that serves the sub-region. But in the interim, while that is happening, and there are a couple of organizations who are working on those, and it will be useful to collaborate a lot more on that, focused on the African Union broadly and also at the SADC states. However, I think that, again, to Adrian's point around collaboration, this is where collaboration would do the best in terms of growing capacity in the individual countries and by the organizations interested in this issue, to ensure that there's progressive development of jurisprudence around this, and that the courts within the region are aware of the development internationally and even in the region. For example, the decision of the ECOWAS court, in the Togo case and other cases that have been highlighted today, should be used as persuasive precedent or persuasive jurisprudence in the filings in this court, to show that there's been advancement in this line. And so, collaboration around growing capacity, sharing persuasive jurisprudence from within Africa, maybe not necessarily, international jurisprudence, but from within Africa, has worked in certain cases. And then, equally, for organizations in the sub-region, also thinking about, training to understand what internet shutdowns are broadly, and how to litigate them before the local courts. And then, of course, the African Commission is always available, as a mechanism, even though that comes after exhaustion of local remedies or where those local remedies do not exist. And so, there are definitely a lot of available options. And again, in the event that participants are interested in working on this and don't have organizations to reach out to, I'm sure reaching out to Media Defense would help. And we are also usually willing to get in contact with such people and put them in touch with partners in the sub-region that are working on these issues.
Thanks so much. I think we've really come to the end of our session. We literally have 2 more minutes, so I think I'll probably just wrap up now. I want to say thank you very much for all of our panelists for their really insightful contributions on this topic, and also to all the attendees that have really livened the Q&A session. I know there's some questions that we weren't able to get to, so potentially reach out to any of the panelists and Media Defense if you wanted to continue any of these discussions offline. Saying that, thank you so much, and hopefully we'll be able to continue these discussions at some later stage. So enjoy the rest of your day and the rest of the forum, and thanks very much for joining today's session. Thank you, everyone.
Thank you, Saba, for a wonderful work.
Thanks, guys.
You did a very good work moderating this session. Thank you.
Thanks so much, Moderator. Thanks.
Thank you.
Bye, everyone.
Okay, bye, everyone.
Bye.
All right.